Well, we want to begin on time because after all, we know that SMU Law School today at 3 o'clock, we're going to have the alumni reunion. And so that's the reason why the conference will be ends early. I am so honored to have the panelists here with me today. And for me, there's, when people say that one person cannot change the whole world, that's wrong, because we in the patent law world, particularly with patent litigation, we know that there's one person did change the whole world. And the panelists today will share with us their poignant stories, funny, serious, entertaining, as well as their tribute to the legendary Judge Ward. Because to me personally, one person that did change the whole world for me in patent law and also put Texas on the map and serve and help patent litigation, streamlining it and elevating the ideas that district court judges plays a really important role in shaping patent law, and also that district and also Judge Ward to me is a symbol of that one person taking an area of law, of litigation that many judges out there are so afraid, and transforming it, and transform the Eastern District of Texas into the centers of patent litigation itself. And the panelists today will share with us, and let me introduce them. We have next to me here is Mr. George Bramblett. He is a distinguished alumni of SMU. And Mr. Bramblett, he is the attorney where the companies will go to. Essentially, that is bet the company lawyer. He's a member of the Trial Lawyers of the Year. Actually, he was selected as a Trial Lawyer of the Year by the Dallas Bars in 2001. And he has been litigating for more than 30 years. And in 2009, both Senator Hutchinson and Senator Cornyn appointed actually Mr. Bramblett to serve on the Federal Judicial Evaluation Committee. That's a really important committee evaluating essentially candidates for the advice and consent, and assist the senators in their advice and consent in their prospective appointments on the federal bench, and also with U.S. attorneys as well. Mr. Bramblett have received numerous awards as a trial litigator in the United States here. I will not list all of them out, but I am so grateful that Mr. Bramblett is here, and he will help us to share his stories about Judge Ward. I'm going to introduce all the panelists as one. And next to him is Mr. Clyde Simmons. And he is the partner at the Siemensberg, Phillips, and Smith law firm in the Eastern District of Texas. Now, Mr. Simmons is also an alumnus of SMU. He came here as a Sumner Scholar. This is a very, very, very distinguished scholarship that we provided to the selected fields of SMU law students. Mr. Simmons, he's a litigator, and he's been in litigation, commercial litigation, IP litigation for numerous years. And what we have done extraordinarily that he's essentially, he founded the Eastern Districts of Texas Bar Association. And he serves as the founding president and subsequently for unprecedented 4 terms of that association as well. And I am so pleased that he's going to help us today, sharing with us all the stories so that we can pay tribute to Judge Ward. Next to him is Hilda Galvan. Hilda is not a stranger at all to SMU. In fact, this year I had the privilege of having Hilda on the panel talking to the students about IP practice, particularly as a patent litigator. Hilda Galvin is one of the top IP, particularly patent litigators in Texas, a go-to attorneys here. She is the head of Jones Day for the IP patent practice. And if you look at some of the cases that she has done, for example, she has successfully in the cases representing IBM in patent enforcement actions against Amazon.com as one of the many cases that she's have done. And I'm so pleased that to have Ms. Galvin here. And by the way, she's also served as a master's, and also we work together at the Barbara M.G.'s Inn of Court, and she's one of the officers at the Inn of Court. And next to hers is Chad Everingham. Well, I call him, he is a former magistrate judge, and so sometimes I don't like to call people by their first name or last name, so I have to call him as a judge here. Okay. So Judge Everingham, currently he's a partner in practice at Aiken Gum. He came to this panel with really special connection with Judge Ward. He will share with us about that. But currently, he's with the private firm. But before that, he serves as a magistrate judge in the Eastern District of Texas. And as you know, that as a former magistrate judge, he presided over numerous Markman hearings, complex cases, very important cases. And before that, he was in private practice for 6 years, and prior to that, he also served as a law clerk to Judge Ward. So with that, I'm going to sit down because I, by myself, cannot do justice to pay tribute to Judge Ward. These distinguished panels here, they will help us and take us back to history a little bit. We laugh with them, and perhaps we cry with them as well. All right, thank you so much.
Thank you. Thank you. Well, I think this whole thing started about 6 months ago, and the people at SMU called T. John Ward, and they asked him a question. Do you believe in free speech? And T. John Ward said, believe in it. I've presided over several cases. I've been affirmed by the Fifth Circuit in free speech. And he said, why do you ask? And she said, well, we want you to give one on April the 20th, today. And so we're here. And let me say, I've known T. John Ward a long time. I've heard him speak. I've heard him talk in cases. And my friends, you're all going to get your money's worth today. That was a nice introduction, John. And I know at the lunch today, John will do, as he always does, a modest appraisal. I'm honored, I'm humbled. And T. John, when you say that, I'm reminded of the Golda Meir quote when someone once said that, and she said, don't be so humble, you're not that great. And I can say that to you. So I am honored and humbled to be here and to be back on my campus, SMU, for this great occasion. And I'm very pleased to be able to share some thoughts with you. I don't know, I hope nobody cries, and I'm glad that there were some laughs, but it's a pleasure to be here. You know, John's has a good story. It's an inspiring story. You could even say unlikely. Oh, I don't know about unlikely. I hope, especially for the young people in the audience, you will understand and appreciate his story and how success in law practice is not always a straight line, as they advertise. If I know you're here because you're interested in IP work, but certainly for John, he didn't come out of Baylor Law School with the idea of being an IP lawyer. And I think it's instructive for all of us along the lines of what you said about how your career path can make a difference. He did grow up in modest, humble circumstances to great, loving parents, grew up in a rural area, went to Texas Tech undergraduate school, and where he met Sissy. But I think the most interesting and probably embarrassing thing I can say about John, and I always like to bring this up when we're around people that don't know him, is that when he was at Texas Tech, he was a cheerleader. Now, you see these cheerleaders today, and they're flipping around and jumping up and down and all of that. Well, back in his day, in our day, a cheerleader was elected by your fraternity, and it was a popularity thing. But to think of T. John Ward as a cheerleader running with Royal Ferguson, they had a team. Royal Ferguson was running for student body president. John was running for cheerleader. They both won, and interestingly had similar career patterns. Law school, and then a successful career as a lawyer, and then going on to be also a district judge who made a difference. So John has a great story, and after he graduated from Baylor, and as you pointed out, was recently elected Baylor Lawyer of the Year, which is a high honor in Baptist Baylor circumstances, and he should be, but decided to go back where he grew up in a rural part of the state, and he went back to East Texas to begin his practice. And I think that what is interesting and inspiring about John's story is that he tried all kinds of cases. He was not a plaintiff lawyer per se. In fact, mostly he was thought of, kind of like I was, and that's the way I thought of John, as a defense lawyer. But because he was a good trial lawyer and because he got extensive experience, and we all worry about whether that's evaporating. I don't know whether John's going to talk about that, but I am concerned about it, about the fact that you wonder, and you don't want to romanticize your past. You don't want to say, you can't do this again. But we all think about how difficult it is to replicate a career like John's and the experience that he got. So John tried everything, and he got the reputation of being the guy to go to in a civil dispute and criminal cases. And I've often talked to John about kind of when it is you kind of begin to think you may have arrived in your profession. And I think it occurs when you get hired by other lawyers. You get hired by other lawyers because they have a case, they're unsure about whether they can try it or they ought to try it. And so they call you in. And that was the story of John's career. He got to try exceptional cases because his fellow lawyers said, look, I've taken it as far as I can go, and I'm going to trial, and I better get T. John. And then the second aspect that I think is even more important in understanding a career arc and why he's made a difference in what he's doing is that when a lawyer got in trouble, they called John. Malpractice case, a grievance, a difficult issue. And to me, that's the high calling as a trial lawyer when you get called in by your peers. And it's the greatest affirmation. So as a result, in the past generation ahead of us, the lawyer that we all admire was Edward Bennett Williams. Remember, in Washington, D.C., and they wrote a biography about him. You don't have many biographies about lawyers. And the biography was The Man to Call, The Man to See. And that's the way I would describe John's career in East Texas and in Texas. He was the guy to see in East Texas when you really were in trouble and when you really needed help. Now, my point of view for John is pre-Article 3. In other words, prior to 1999, when he was appointed by President Clinton, one of the last appointees of Clinton, by the way, to the federal bench. So my perspective is pre-Article 3, and I knew him and appreciate him as a peer. And I think that the legacy of John is not about IP from my point of view. In fact, during most of his successful career, the words T. John Ward and IP didn't appear in the same sentence, right? It came late to it. I mean, it's instructive for all of us. So John, in my opinion, represents the best of our generation. He's somebody that has an earned status. If I were king, I would appoint federal judges or state judges based upon experience. I would want to have experienced people in benches as opposed to certain current trends where they appoint political people and they like to appoint them unusually young so that they'll be there forever, as if that is somehow helpful to them. I take it the opposite view. I take the T. John Ward view, I take the Royal Ferguson view, and I want to have experienced people, because when you have experience and you're an experienced trial lawyer, the lawyers and the clients pay attention. And when you go to trial, the judge is not afraid of trial. And so that's the hallmark of John's career. As you can tell, I'm a great admirer of John, and I think everything I've said is the truth, except you didn't do backflips, did you? You didn't do those. So to quote from another person from a small town, a Mark Twain quote. He once said that fewer things are harder to put up with than the annoyance of a good example. And T. John Ward is a good example. He's a good example for his friends. He's a good example for our bar. He's an example of earned status and how a person can make a difference in being a federal judge. And from a personal point of view, what I appreciate is John's approach to not just the IP cases, but to the civil rights cases, to maintaining the rights for all people. And he has taken courageous stands in redistricting cases. And so his legacy is there quite apart from the IP world. Thank you.
Well, I'm fortunate to have only gotten in trouble with Judge Ward one time that I can remember. And fortunately, it wasn't in the Eastern District of Texas. It was on a judicial panel in Lake Tahoe with the State Bar Advanced Patent Litigation Seminar. And there was a panel. Judge Schell was on it, Judge Ward was on it, and I was making the introductions. There were some other judges on it. And when I was introducing Judge Schell, I started describing how he maintained such control over his courtroom with being mild-mannered, not raising his voice, never becoming irritable. And I knew as I started down that path that I was in a lot of trouble. But, you know, sometimes when you're in trouble, you're in so much trouble and you're so far down the path of trouble that there's just nothing to do but keep going. And so I kept going a little bit. And then I heard that booming voice from the end of the panel there that said, "Well, what are you suggesting about me, counsel?" And, you know, I just, you got to be straight with Judge Ward because, you know, that's, everybody knows that they practice in front of me. And I just said, "Well, Judge, I'm not talking about you. I'm talking about Judge Schell." So, but I think that's probably the only time I've ever gotten in trouble with Judge Ward. Having thought about that experience, I accepted this opportunity to participate in this tribute with a little bit of trepidation. And misery and joy and company, I went ahead and sent out some emails to some of the leading lawyers in East Texas asking them for their input so that I can tell Judge Ward, now not everything that I say is coming from me. Some of this is coming from these other lawyers. And they did make me promise that I wouldn't identify them. So here I stand all alone anyway. One of the things I think that you know about Judge Ward is that in limine is a little bit of a treacherous situation. You know, when Judge Ward enters an in limine, that's something that you've got to be very concerned about and very careful with in his courtroom. One lawyer told me that the fourth horse of the apocalypse is named in limine. Another lawyer said that if there's any chance at all that you might violate an in limine in Judge Ward's courtroom, either accidentally or on purpose, you better bring two things: your toothbrush and a change of undergarments. Consistency was a theme, I think, that I experienced in Judge Ward's court, and others have experienced there. As it was related to me that if the courtroom was a Monopoly game, and you landed on Boardwalk in Judge Ward's court, you knew exactly what you were going to have to pay. And I would put it this way, that if you landed on go to jail, you would go to jail, and when you passed go, you wouldn't collect your $200. Because he would be consistent, you would know exactly what the rules were, and you would know that those rules were going to be enforced in a way that was very, very consistent. Being a good Baylor lawyer, I've been told that there was a no dancing rule. in Judge Ward's courtroom. If you are asked a question as counsel, even if the question cuts you to the core, cuts your position to the core, you better answer it. You better not dance around about it. You better just tell it like it is. Same with expert witnesses. On cross-examination, if your expert's getting cross-examined, you better make sure that he knows not to dance around. He just needs to answer the question. I liked what one lawyer told me. He said, you need to make sure that your expert knows on cross-examination just to shut up and answer the questions. Now, direct and to the point may not always win, but it will definitely keep you in the race. And as those of us who try a lot of cases know, in the course of a career, staying in the race with your credibility is what it all boils down to, and that's all you have at the end of the day is your credibility and your reputation, which is something that I think Judge Ward knew and has taught those of us who have practiced before him. A few lessons to live by that were taught by Judge Ward. The question I proposed to the folks that I solicited input from was, what were the lessons that lawyers learned to live by in Judge Ward's court? One of my favorites was, when you hit oil, stop drilling. Even a bad settlement is sometimes worth more than a good case. Always try to help the judge and always answer the question. Who hasn't been in Judge Ward's court and had the question propounded, how are you helping me, counselor? Now, there are two ways to lose a case, on the merits and on discovery abuse. Be honest and tell the truth every time. Even if you didn't grow up as a Boy Scout, act like one. If you can't put on a defense of a multi-million-dollar case in a day or two, then you don't know how to focus your presentation. 1 year is plenty of time to develop and try a lawsuit if you are serious about developing and trying a lawsuit. A motion for sanctions increases risk that someone is going to get sanctioned, just not always who you expect. I think the word that fits Judge Ward the most, I think, is predictability. And I think for those, again, of us who try cases, that's the thing that we really want the most as a trial lawyer, predictability. Because with a trial judge, if a judge is predictable, we can advise our clients and we can tell them what to expect. And if we prepare for that predictability and the predictability is delivered, then we can represent our clients in a way that is important, and I think that they can make the right decisions based on that predictability. And for those of us who are down in the trenches in the courthouse, that's what Judge Ward brought, predictability, and that's what we came to expect and came to appreciate. Now that Judge Ward is in retirement, I can give you a clue, one of the trade secrets, if you will, of the trial lawyers in East Texas that try cases. There's a lot of speculation on how do we know what the judge is going to do right before something. I'm going to put it this way, how could we know of the impending doom that was about to befall the courtroom when something was about to happen? Well, there was a clue that we were watching for, and I wouldn't tell you this if the judge wasn't in retirement, but now that he is, I will tell you that there is nothing in the courtroom more important to watch than the color of the judge's ears. Judge Ward, we thank you for your service. Your dedication to our profession and to the rule of law is something that definitely you have made a change. The IP practice aside, that's insignificant, if you will, compared to what you brought to the profession in terms of teaching young lawyers how to be lawyers, how to be honest, how to be forthright, how to be direct, how to be lawyers, if you will. We appreciate you for that. We hope you many, many years practicing law with your son. I have a daughter who's in law school, so I know how you must feel practicing law with your son, and we wish you the best and many years of, happy years of practice and trying lawsuits with Johnny. Thank you, Judge.
Scoot this back a little. Well, it's a great privilege to be a part of this group who's honoring Judge Ward for all that he did for our legal profession and for the IP community. My perspective comes as one of a legion of lawyers that were from outside of the Eastern District of Texas and grew up practicing patent law in front of Judge Ward. I first came to know Judge Ward shortly before he went on the bench in September of 1999. He was trying his last patent infringement case against our client, Texas Instruments. I was a fairly young lawyer. What I remember is watching him and watching the way the jury paid attention when he spoke. I remember how he was always prepared and could deal with the unpredictability of a trial so very easily. And what I remember most was the way that he treated the lawyers, not only the lawyers on his team, but also the lawyers on our team. He was always honest and he was always fair. At his confirmation hearing, Senator Kay Bailey Hutchinson told the Senate Judiciary Committee of a letter she had received from one of her constituents about the nomination of T. John Ward as a federal district court judge for the Eastern District of Texas. The constituent wrote, "John Ward brings complete preparation, a studied atmosphere, and a balance. He will be a great judge." This constituent captured in those few words what I saw in my first encounter with Judge Ward and what I would continue to see the 12 years that he was on the bench. And while much can be said of Judge Ward's complete preparation and studied atmosphere, balance is what I remember most. Judge Ward demanded much of those lawyers that practiced before him, but that was balanced by his mentoring of those lawyers. Judge Ward required strict compliance with the rules, but that was balanced by his even-handed enforcement of those rules. Judge Ward was protective of the court's time in the courtroom, but that was balanced with his generosity of his time outside of the courtroom. Those of you who have practiced before Judge Ward know what I mean when I say that he demanded much of the lawyers who practiced before him. Judge Ward had tried hundreds of cases before he was appointed to the bench. He knew what it meant to be a trial lawyer, and he expected the lawyers who entered his courtroom to have that same level of knowledge. He expected every lawyer that entered his courtroom to have that same level of preparation. But Judge Ward balanced his high expectations of those lawyers with his willingness to mentor those lawyers in his own very unique way. In his early years on the bench, Judge Ward allowed the party's experts to testify at the claim construction hearing. And I remember one of the lawyers on our team. She was a fifth-year associate. She was cross-examining the plaintiff's expert. The expert's testimony at the hearing was inconsistent with his testimony at the deposition, so the young lawyer attempted to impeach the witness. And after her second attempt at impeaching the witness, we could all see that Judge Ward, his fiery temper, as it's often referred to, was about to be unleashed. As Clyde said, his ears and his face turned red. And then he leaned forward, and again, he didn't say anything at that point, but there was more inconsistent testimony and another attempt to impeach. At this point, Judge Ward pulled off his glasses, and he gave the young lawyer a very stern look and said, "You are not properly impeaching the witness. You have to ask the exact question that was asked at the deposition. If you attempt to impeach the witness again, you had better do it right." So there was some more inconsistent testimony. The young lawyer looked at Judge Ward, and thanks to his stern guidance, she asked the exact question that she had asked at the deposition. Proper impeachment done. Judge Ward leaned back in his chair, put his glasses back on, and there was a glimmer of a smile as if to say, lesson completed. To this day, that lawyer says, Judge Ward taught her more about how to conduct herself in the courtroom in that brief encounter than she has ever learned from any other judge. Another example of Judge Ward's balance between his high expectations and his mentoring of lawyers is an example of my own. I was still, again, a fairly young lawyer, and at trial my responsibilities included handling any arguments to the court on exhibits and demonstratives. And we were near the end of trial, and the last set of demonstratives to be dealt with were those for closing argument. I was told by our lead trial lawyer that I had to have objections to the other side's closing exhibits. Period. End of story. So me and a couple of other lawyers struggled all night long to come up with objections. The most we could do was objection argumentative. A valid objection, maybe not for slides at closing argument, but the senior attorney instructed me to make the objections, so I did. First slide, objection, argumentative, overruled. Second slide, objection, argumentative, overruled. Third slide, objection, argumentative, overruled. Clearly a pattern was developing and Judge Ward saw it. And I could see the Judge Ward's face, and it was turning red. His body was leaning forward in his chair, and his hand was reaching for his glasses. We made eye contact, and with one look, I was taught my lesson. Do not ever put a lawyer in the position that you are now in. He didn't say a word, though. He just sat back into his chair, lesson completed. And trust me, I have never, nor will I allow anyone on my team to ever put a lawyer in that position. I'm sure that this is just one or two of many types of stories and lessons as folks have learned over the years from Judge Ward. The overarching lesson has been the one of balance. The balance between the high expectations that Judge Ward sets for the lawyers who practice before him, and at the same time, he's teaching of those very same lawyers. There's also a balance between Judge Ward's requirement that the lawyers strictly comply with the rules on the one hand, and his very even-handed enforcement of those rules. We always hear that in East Texas, the jurors are plaintiff-friendly, and we often hear, typically from an outsider in an article, about how even the judge's rulings are patent-friendly. And while I'll be the first to admit I didn't always agree with Judge Ward's rulings on claim construction or on dispositive motions, I always appreciated the even-handed way in which he enforced the rules. In preparing for this speech, I reached out to a number of lawyers, East Coast, West Coast, Midwest, South, and other parts of Texas. And I asked about Judge Ward's requirement that lawyers strictly comply with the rules. And every single one of them, regardless of whether they were primarily plaintiff's counsel or defense counsel, agreed without hesitation that although Judge Ward required strict compliance with the rules, he was always even-handed in his enforcement of the rules. With Judge Ward, there's also a balance between his protectiveness of the court's time in the courtroom and his generosity with his time outside of the courtroom. Judge Ward is well known for limiting the time that parties have to put on evidence at trial, for his chess clock, and for his strict adherence to time limits. With Judge Ward, you learned early, in the words of Franklin Roosevelt, be sincere, be brief, and be seated. Although Judge Ward was very protective of the court's time in the courtroom, he was also extremely generous with his time outside of the courtroom. He spent countless hours talking to lawyers across the country about the practice of law, about trying patent cases to juries, and about the Eastern District of Texas. He devoted countless hours working on patent cases filed in the Eastern District of Texas, and the harder he worked, the more cases they filed. But because of Judge Ward's generosity on patent cases filed in the Eastern District of Texas, and his generosity with his time, the Eastern District of Texas will never be the same. It will continue to be a better place for everyone. In the words of that very wise constituent, Judge Ward brought complete preparation, studied atmosphere, and most importantly, a balance in his role as a judge. And as that constituent predicted, he was a great judge. Judge Ward, we thank you for that.
Thank you. It's a pleasure to be here today. You know, Professor Wynn asked me to visit with you a little bit today from the perspective of one who has worked for Judge Ward for many years. It's always nice to get to say a few things about a former judge. His contempt powers have been sharply limited lately. I've got a little bit of freedom here today. But in the words of one of our mutual friends, tell only what you know, but don't tell all you know. In January of 1985, I showed up for a job interview at a small firm in East Texas. At that time, I was halfway through my senior year in high school and halfway through my short-lived career as an electric guitarist in a garage band. I didn't know it at the time, but I was the victim of a conspiracy, and the confederating parties were my parents, who were not fans of my electric guitar career, and the managing partner of that small firm, who fortunately was a fan of my parents. I suspect that the job I was interviewing for was mine when I showed up, but I didn't know it at the time. But I was hired on as a runner for that law firm, and I started work shortly after that. Now, I worked for that firm for a couple of years in high school and then in junior college, and then in the summer times when I came back from studying at Stephen F. Austin in Nacogdoches. You know, it was at that law firm that I learned that lawyers were not punchlines for jokes. They were professionals. They were guardians of our liberties. They were advocates for the rights of their clients. They were spokespeople for the meek, philanthropists. And they were officers of institutions that existed to resolve disputes civilly as opposed to through the use of force. You know, lawyers taught me values like civility, compassion, honesty, diligence, and equality. Now, I don't know what other people's experiences were like working in high school running errands for law firms, but that's what mine was like working for a law firm that was managed by John Ward. And that is what made me want to go to law school. You know, I eventually got in and out of Baylor Law School and had the privilege of going to work for Judge Ward as an associate lawyer in Longview. And I can tell you that he instilled precisely the same values on his law partners and his associates that I had observed running errands for him while I was in high school and undergraduate. There was, to put it mildly, a sense of camaraderie and teamwork in every legal effort we pursued. When Judge Ward went to trial as a lawyer, we all went to trial, and we never thought that we'd lose a case. In 1999, when President Clinton appointed him to the federal bench, I was privileged to get to go to work for him as a career clerk. You know, it came as no surprise to me or to anyone else who had ever worked with him that he would quickly become known across the country as one of the hardest working federal judges in America. You know, I can recall a time in East Texas where patent cases were few and far between. A judge has to want to work hard and pay attention to the details and learn the technology and the law to manage these types of cases. I was present at a discussion earlier this week where someone asked some law students, why do you want to go into patent law? And someone said, well, that's the high stakes stuff. Those are the sexy cases. You know, I don't think I'd ever describe patent cases sexy. It's tough duty on a judge. When a judge has to manage hundreds of them, it is really tough duty. You know, patent cases from an administrative standpoint are weighted for statistical purposes by the court administrative office between 4 and 5 times what a typical civil case is. You know, for instance, a car accident case is weighted. I would suggest to you that that number is too low. You know, there's no financial incentive or special stipend available to a judge who handles more patent cases than his colleagues. There's no year-end bonus tied to the number of Markman's opinions that are turned out by a court. And no salary bump that depends on the number of these cases that one tries to verdict. You know, Judge Ward handled these cases, and hundreds of them, with a sense of duty and a sense of diligence, and without apology. He dug into them like a judge is supposed to do, and he encouraged the people that worked for him to help him develop creative ways to efficiently handle these types of cases, to reduce the expense that's associated with them, consistent with the federal rules, in particular Rule 1. I suspect that every single one of his law clerks would agree with me that the values he sought to instill on the people that worked for him at the court were precisely the same ones that I'd borne witness to my entire working life. When you worked at the court, you were part of a team. It was a collaborative effort fostered by a judge with an open door and an open mind policy, where every point of view was honestly considered. I cannot count the number of staff gatherings, holiday events, or other special type luncheons where Judge Ward addressed the staff and told them that any successes he had had as a lawyer or as a judge was largely the result of the staff that worked for him. I would suggest to you that you should ask yourself, Judge Ward, whether those people on your staff tried, or why they tried so hard to turn out quality work for you. When your quarterback is, as Bill Dawson once called him, top drawer, everybody on the team tries to step up his A game. It's the difference between having a boss that does his job and having a boss that's just a figurehead. You know, I was asked one time what judges I admired most and what traits about them were important to me. What I admired most about Judge Ward was when he got to work, he was completely devoted to his job as a judge. Whatever case Judge Ward was hearing at that time was the most important case he had ever heard. And when he went in that courtroom and put on his robe, got on the bench, he didn't have any friends in there. He didn't have any enemies, but he didn't have any friends. He viewed the role of a judge as one that required him to dispense justice impartially, regardless of a party's race, religion, social status, or means. He certainly, unlike the cheerleading effort, did not view it as some kind of a popularity contest. And he was not one to bow to critics or to rule based on what others thought he should do. Those dispositions would be inconsistent with his oath and with the independence that attaches to an Article III appointment. On behalf of those of us who are fortunate enough to have worked for you, thank you for letting us be a part of your public service. And thank you also for doing your job as a judge. It made us want to come to work every day.
Well, I don't know about you, but I have to drink a whole bottle of water because my tears just keep coming down in my eyes. And also, I want to say thank you to the 4 distinguished panelists for sharing their stories. And so all of us in this room here are so privileged to hear what you have learned, and also the fact that you did what exactly Judge Ward told you, be prepared, and you were extremely prepared. You did even survey of lawyers, your peers, and share with us their story as well. So on behalf of SMU Law School, I say thank you to the panelists for doing your extreme preparation and share with us very intimate stories there as well. And as Mr. Bramblett pointed out, yes, I was the person that asking for the free speech from Judge Ward. And I'm so honored that Judge was here with us. And so I will invite all of you to enjoy SMU and take your leisure time networking and walking over to Koch Auditorium for the most awesome free speech ever that you're going to hear in your life. All right. Thank you.